All right. So good afternoon, everyone. My name is Marcia Drame, and I am the president of the Milwaukee Bar Association. And on behalf of our entire board and staff, I just really wanted to welcome you here today for this forum. This is one of the things that the Milwaukee Bar Association does that benefits our members and also benefits the community at large. So I want to get out of your way so that we can get on with our program, and would like to introduce Judge John D'Amato, who will introduce our moderator. So thank you for being here.
Good afternoon. I'm Judge John D'Amato, and I'm going to be a facilitator and give some assistance to Steve Walters, who's going to moderate today's forum. And I want to welcome all of you on behalf of the Milwaukee Bar Association for being here at the 2016 Milwaukee Bar Association Supreme Court Judicial Forum. The Milwaukee Bar Association is the first bar association who really decided it is so important to inform the electorate that about 25 years ago they held the first judicial forum and have done so ever since. They recognize the importance of an informed electorate, which is why the forum is conducted. Today, this judicial forum will involve the Wisconsin Supreme Court. And we thank Justice Bradley, Judge Kloppenberg, and Judge Donald, who are the candidates for the Supreme Court race, for being here today and participating in this forum. This is actually the first of 3 forums that the Milwaukee Bar Association is going to do. There will be a second Supreme Court forum sometime in March, and there will be a circuit court judicial forum for contested races in March. It'll be March 15th, so you should mark that date in your calendars. We also want to thank the many media outlets who are here. A lot of people can't be here, but because they are here, they will be able to report on this forum, and they will be able to help inform the electorate. With respect to the races this year, I do want to recognize we just don't have a Supreme Court race this year. There is an election for District 1 Court of Appeals. Joan Kessler is running. If she's here, she can stand up. In fact, if any of the candidates for their races are here, please stand up and let us know that you're here. We also have Judge Mary Kuhnmunch, who is running unopposed. I believe she is here. We have Judge Christopher Foley, who is running unopposed. He is in the back of the room. Judge Stephanie Rothstein is running unopposed. I don't believe she's able to be here today. Judge Glenn Yamahiro is running unopposed. He is here today. Judge Paul Raffel and Judge Michelle Havas are here today. There are challengers, Hannah Dugan and Jean Keiss. They are also present here today, and we recognize your presence. Now, with respect to the format, I want you to know that on all the tables, at the end of the table, there are pieces of paper. This is an interactive forum. Each of you will have the opportunity to write out a question, and you can submit the question. They'll be picked up by members of the Milwaukee Bar Association. They'll be handed over to me, and I'll look them over and get them up to Steve Walters, who will moderate today's forum. But this gives you an opportunity to pose questions to the candidates. We will only be going till 12:55. We'll get in as many of the questions as we can. Steve will explain the format of opening statements, the questioning, and the closing statements. So at this time, I'd like to introduce Steve Walters, who will be the moderator. Steve is the senior producer of the Wisconsin Eye. He's been doing so since 2009. The Wisconsin Eye is a nonprofit. It's a private public affairs cable network in Wisconsin, and it actually provides gavel-to-gavel coverage of what goes on in the Wisconsin legislature. He previously has worked in the Capitol for the Milwaukee Sentinel, and between 1988 and 2009 worked with the Milwaukee Journal-Sentinel. So I want to welcome Steve Walters for being here and thank him for being our moderator.
Thank you, Your Honor. While we're applauding, let's thank our 3 Supreme Court candidates for coming. Just quickly, to open it with applause. Thank you. The format for today, every one of the candidates will give a 2-minute opening remark. The order has been drawn in a drawing earlier. As Judge D'Amato explained, your questions will be collected, submitted to him, and he will go through them. And the answers to the questions will be 2 minutes from each candidate. There'll be, thank you for our scorer, time scorer up here. There will be 1 minute closing remarks, and that has also been drawn by lot. So I'm going to introduce the candidates in the order in which they will be giving their opening statements. Justice Rebecca Bradley was appointed to serve on the Wisconsin Supreme Court by Governor Scott Walker in October 2015 after the death of Justice Pat Crooks. Previously, she served on the Wisconsin Court of Appeals and as a Milwaukee County Circuit Court judge. Before her appointment to the Milwaukee County Circuit Court, she practiced law for over 16 years. A Milwaukee native, Justice Bradley graduated from Divine Savior Holy Angels High School and then attended Marquette University. She earned her law degree from UW Law School. Justice Bradley. Judge Joanne Kloppenberg is presiding judge for District 4 Court of Appeals. She was elected to the Court of Appeals in 2012. She served for 23 years as an assistant attorney general at the Wisconsin Department of Justice, where she prosecuted and litigated cases involving constitutional, administrative, and environmental law. She graduated from UW Law School, earned a master's at Princeton University, and a bachelor's degree at Yale University, Judge Kloppenberg. Honorable Joseph Donald was appointed a Milwaukee County Circuit Court judge in 1996, elected to a full term in 1997, and re-elected in 1997, 2003, 2009, and 2015. His current rotational assignment is on the General Felony Criminal Division. He has also served on Children's Court, Drug Court, and Civil Probate Divisions. A Milwaukee native, Judge Donald graduated from Shorewood High School and Marquette University Law School. Those are the backgrounds of our three candidates. And Justice Bradley, would you go first with your first opening statement?
Thank you. Good afternoon, everyone. I would first like to thank Steve Walters for moderating this forum, the Milwaukee Bar Association for hosting it, Judge Kloppenberg and Judge Donald for participating, and all of you for attending. After practicing law for over 16 years as a civil litigator, business transactional attorney, and an arbitrator, I felt called to serve the people of Wisconsin as a member of the judiciary. I care very deeply about my community and our state, and I believe it is so important that we have justices on our state Supreme Court who will set aside their personal policy preferences and political inclinations and apply the law as it is written. I believe it is so important that we have justices on our state's highest court who will say what the law is and not what they may wish it to be. I have faithfully exercised this duty that I recognize in hundreds of cases as a circuit court judge, as a judge on the Wisconsin Court of Appeals, and now as a state Supreme Court justice. It is my honor and my privilege to serve the people of Wisconsin. And in my 20 years as a member of the legal profession and the judicial profession, I have always been able to get along with my colleagues and even opposing counsel in the heat of battle when I was a practicing attorney. Collegiality on our state's highest court is very important not only to the legal community, but also to all of the people of Wisconsin. And I am bringing an excellent judicial temperament and a collegial manner to our state's highest court. I am looking forward to continuing to run a very positive and nonpartisan campaign as I ask the people of Wisconsin to elect me to a full term on our state's highest court. Thank you.
Thank you, Justice Bradley. And just a reminder, as you develop questions for each candidate, please make them for all three candidates and not to anyone specifically. Sorry for the interruption. Judge Kloppenberg, please.
Thank you so much to the Milwaukee Bar Association and to all of you for paying attention to this very important election. This race is about the future of our court. It's about what kind of court the court should be and what kind of justices we should be electing to the court. I'm the only candidate who's been to all 72 counties and across the state. People's hopes for the court are the same as yours. They want a court where everyone feels like they've had a fair shake, where the outcome of any case is not a foregone conclusion, where the justices approach every case with an open mind, where justice is being done without fear or favor. And that's why I'm running. I am running to because I want to stand up to the partisan politics and the special interests that threaten to undermine the independence and integrity of our court. The stakes are high and the choice is clear. As we answer your questions this afternoon, you will see that no other candidate can match the breadth and depth of my judicial and legal experience. No other candidate has my proven track record as an impartial and thoughtful and fair appellate court decision maker. No other candidate has represented the people of Wisconsin in courts around this great state. No other candidate has my ability to reach out and connect with voters statewide to build the strong grassroots network that's necessary to win this race. I am the only candidate with the background and the backbone that the voters can count on to stand up for the people of Wisconsin and against special interests and partisan politics. Together, we can, in this election, work for a court that serves the interests of all of the people of Wisconsin. Thank you.
Thank you, Judge Kloppenberg. Judge Donald, please.
All right, thank you. I want to thank everyone for showing up. Steve, thank you for moderating.
Thank you, sir.
I am delighted to be here. I am delighted to speak to you about my candidacy for the state Supreme Court. The reason that I am so delighted is that I am the first in my family to obtain a college degree and to go to law school. I can't imagine how happy and pleased my mother would be to see this room, to see me here speaking before all of you about my candidacy for the state Supreme Court. I'm running to ensure that we have a fair and impartial court. I'm running to bring independence to our court. Now, both of my opponents have talked about what they plan to do, but they've yet to talk about the real issues and the real problems. And what is our biggest issue right now is integrity in our court. Because politics has influenced our court, it's influencing the whole process on how we elect a Supreme Court justice. And that really concerns me. This election is vital to the independence of our court. Because if we do not truly elect an independent candidate, we are going to be stuck with a division and a divisive court, an ideologue that may be on the court for the next 30 years. So it is time, Wisconsin, to ensure that we have a fair and independent court, and I'm running based on my background and experience as a judge for over 20 years. I've handled over 10,000 cases. It is time to have a justice on our court who will enforce the law and the Constitution. Thank you.
Thank you, Judge Donald. We'll now go to some questions. The order in which candidates answer has also been determined by lot and will be rotated. The first, Judge Kloppenberg, first question, then Judge Donald, then Justice Bradley. First question. There's a public perception that the lack of collegiality on the court is interfering with the work of the court. If elected, what would each of you do to restore collegiality on the court? Judge Kloppenberg.
Well, I was very honored to be chosen to be the presiding judge in my district in the Court of Appeals after only 3 years on the bench. And I take the justices at their word. They know that they need to be more collegial and they're working at it. The real issue is the concerns the people have with the injection of partisan politics and special interests onto the court. With partisan politics come agendas that belong in the executive and legislative branches, but they shouldn't be bleeding over into our court. With the massive amounts of expenditures from entities that don't have to disclose their donors comes the perception that justice is for sale. What the critical issue for this court is to decide cases without fear or favor, and we need to elect a justice who has shown that she is independent. I have a record of issuing decisions that are fair and impartial and thoughtful and follow the law. And I also have shown that I will have the courage and the skill to stand up to the influence of partisan politics and special interests on the court.
Thank you. Judge Donald?
Well, when I looked at the seating arrangement, I couldn't have planned this better myself. I have one candidate on my right, one on my left. By the end of this debate, you will know which one does not look like the other. It is time. It is time that we have a truly independent court. And everyone in here knows what's going on in our court. Everyone sees it. Our state Supreme Court used to have a national reputation. It now also has a national reputation, but not the one that it wants. So let's be honest about what is going on in this state. Politics has infiltrated our state Supreme Court to the degree that our justices, in my opinion, may not even be talking to each other. I have spent my whole life bridging differences. I have overcome economic differences, racial differences, cultural differences. So I'm bringing that skill, that ability to our state Supreme Court because it is vitally needed. Everyone in here already knows that. What we need to do is to convince the voters that it is their court. It's not Governor Walker's court. It's not the Republican Party's court. It's not Club for Growth's court. It is the people's court. And that's what we have to ensure, that it remains the people's court. This is a government of the people, by the people, and for the people.
Thank you. Justice Bradley, please.
Thank you. I believe the question related to collegiality on the court and what each of us would bring to the court in that respect. So I want to get back to what the question actually was. And I'm in the best position of the three candidates to comment on that because I have been serving on the state Supreme Court and interacting with each of my colleagues for the last 3.5 months. And I'm very pleased to report that each of my colleagues welcomed me warmly to the state Supreme Court and helped ease my transition from the Court of Appeals. I mentioned collegiality specifically in my opening statement because I believe that that is a very critical issue for the court, and it is an issue that I take personal responsibility for. As I mentioned at the outset, I have always been able to get along with my colleagues in every working environment that I have ever enjoyed professionally. One of my favorite parts of my job as a state Supreme Court justice is when we retire to our conference room to talk about the cases we just heard oral arguments about. And each of us go around the room and share our perspectives and our perceptions of how the case should be decided. I am very pleased to report to everyone that those conversations that occur among my colleagues on the court are always very collegial and professional. And as a member of the state Supreme Court, I can tell you that I always respect the opinions of my colleagues, even when I disagree with them. In fact, I find that to be one of the most interesting parts of the job when we talk about our differing perspectives. Those conversations are always very respectful and collegial, and I am demonstrating that I am adding something very positive to our state's highest court, as I am the latest member of that court, and it is a very collegial and positive experience for me.
Thank you. Our second question will go to Judge Donald, and then Justice Bradley, then Judge Kloppenberg. Judge Donald, should court rules provide a mechanism for resolution of ethical complaints involving justices? For example, could a panel of Court of Appeals judges be convened to resolve complaints against a justice? Sir.
I think that that's probably a good idea to ensure that the voters have integrity and faith in our court. Integrity is key. Our court has no armies to enforce its rulings. Our rulings are enforced because the people accept them. They accept them because they believe in our system of democracy. So I think it's important that we ensure that we do everything we can to enforce the integrity of our court in the belief that the decisions of our court and our justices are fair and impartial. And the best way to do that is to ensure that if there are conflicts of interest, if there are situations where matters need to be addressed, that they shouldn't be just swept under the rug or pushed aside. Everyone has heard the old adage, justice delayed is justice denied. And I think it is important to ensure that the citizens believe that they are getting a fair shake out of our court. So yes, there should be a panel that reviews those issues that relate to matters of integrity.
Justice Bradley, please.
Thank you. With respect to the resolution of ethics complaints and a potential change in those rules, that is one of the responsibilities of the state Supreme Court. It is one of my responsibilities to consider possible changes to the current system that we have. Before I would take a position or make any judgments about that, I would want to participate in and follow the process that has been established for considering changes to our rules. And part of that process includes having hearings and hearing from all stakeholders in the system so that we can gather all the information necessary to make an informed, a very well-informed decision on such an important rules change. So before I would take a position on something like that, I would certainly want to hear from all of the stakeholders who wish to take a position and be heard on that issue, and I certainly support the process that the court has in place for making changes to rules in that manner.
Judge Kloppenberg, please.
There's no question that the entire Code of Judicial Conduct, including the recusal rules within that code, bear review. And Justice Bradley has voted with Justices Gableman, Prosser, Ziegler, and Rogensack to quash efforts to review the Code of Conduct, including the recusal rules, in a public process, and have also kept secret their selection of members of the Judicial Commission, which is charged with investigating ethics complaints against the judges and the justices. We need more transparency, not less, in the administrative and operational proceedings before the court, and an open process for reviewing the Judicial Code of Conduct is a step in the right direction.
Thank you. Next question.
May I respond briefly?
Very briefly, ma'am.
Very briefly. In response to Judge Kloppenberg's statement, I just wanted to clarify that the petition that brought that before the state Supreme Court was not in compliance with the process for such petitions to be brought before the court. It does not mean that the court is not considering it. It's just that the proper process was not followed.
The third question to Justice Bradley, then Judge Donald, then Judge Kloppenberg. Justice Bradley, a question on transparency of court operations. Should administrative conferences remain open? Should justices take votes on administrative matters via email?
With respect to that question, administrative conferences to some extent are held privately and some are held publicly. And we have rules that are established in our internal operating procedures that govern whether something is held privately or publicly. When we have rules, petitions, hearings, when we're considering changes like that, for example, there are changes pending before the court with respect to the Office of Lawyer Regulation. It's very important that we have public hearings on all of those, again, so that we can hear from all of the stakeholders, anyone from the public who wishes to be heard. We absolutely conduct those hearings publicly, and I support full transparency in that process. When the court is deliberating over certain matters, some of those deliberations take place in the privacy of our conference room. But that's all pursuant to the court's internal operating procedures, but I certainly support full transparency on the court when it comes to voting on matters in open conference.
And I think I misspoke. Judge Kloppenberg, it's your turn to go second, please.
Transparency is best for the administrative and operational proceedings for our court, just as transparency is best for the democratic process as a whole. There, as I noted before, Justice Bradley voted with other justices on the court to make the court's procedures less transparent than they used to be. I think we need to return to a more open court that does its business other than decisional conferences on cases before it in public, and that that email balloting is a step away from the kind of collegial and open conduct of the court's business.
Judge Donald, please.
In my 20 years as a trial court judge, every hearing that I've had has been in open court. There is a record being made. People have to understand what the court is doing and why it is doing it. And I think that when you have meetings and votes by email, it gives the appearance that something else is going on. Something's not quite right. And as I've indicated before, we need to restore integrity in our court. Our citizens are concerned. And the surest way to do that is to do it in open court, to do it in an open proceeding, to do it in a fashion where people can have faith in the decisions that are being made, and that they're not the result of some side deal or secret agreement, because in my opinion, that in essence indicates, again, politics. The court should be open. It should be opened to all the people.
The next question comes from the audience. Judge Klappenberg, your turn to go first. Will you accept PAC money for your campaign? If yes, why? If no, why not? And a follow-up question, should judicial candidates accept assistance from political parties in their campaign? Judge Klappenberg, you're going first, please.
Yes, I will accept PAC money. I will accept money from anyone who is legally allowed to contribute to a candidate's campaign. I will not accept the support of partisan political parties. And that's the choice here, is between someone like myself who has a nonpartisan record as an assistant attorney general, working for 4 attorneys general from both parties, doing the people's business without regard to political ideology, to being elected. I'm the only one on this at this table who was first elected to the position, to the judiciary, as a Court of Appeals judge, issuing hundreds of decisions that are fair, thoughtful, and that follow the law. Not one of them could you say it was written for one partisan political perspective or the other. In contrast to my opponents, we've got Justice Bradley, who is a member of the Republican National Lawyers Association and the Federalist Society, was appointed 3 times by Governor Walker in 3 years to 3 judgeships. The Republican Party circulated her nomination papers for her. She's bringing her partisanship onto the court. And Judge Donald endorsed Rebecca Bradley when she ran for circuit court and was a reference for her when she applied to Governor Walker on the Court of Appeals. We need a justice who, throughout her career, has been independent from all political parties, and that's me.
Judge Donald, it's your turn to go second, sir.
When I first ran for circuit court judge, in order to vote in this state, you need to require proof of residency. Now, in order to vote in this state, you need an official state ID. There are restrictions on the hours in which the polls will be open. There are restrictions on whether or not you can vote on Sunday. And I find it kind of odd that we are now in an environment where our citizens have restrictions on their right to vote, and I'm being attacked because I supported someone who I thought had qualities and capabilities of being a good trial court judge. I still think she does. And that's why I'm running for our state Supreme Court. So let's really look at what's going on here. Whether or not there is PAC money out there, I don't know. No one's offered me PAC money. Whether or not you work with a party, I think creates a problem, because it means you're going to be beholden to whoever that party is. I'm working to be the independent voice of this campaign, and I believe that I am. Yes, I was appointed by Governor Walker. Governor Thompson.
I think it was Governor Thompson, sir.
Governor
Your Honor.
Thompson, I'm sorry. I was thinking of you. I often say, show me a lawyer who calls the governor a friend, and I'll show you a judge. But 3 times, that's a lot. I've been endorsed by Herb Cole. So I'm working really hard to bring independence to our court.
Justice Bradley, please.
Thank you. I think the question was whether, as candidates, we're willing to accept PAC money or assistance from political parties. And I think one of the concerns that I've heard as I've been campaigning around the state is the undue influence of third parties' participation in the campaign process, in the electoral process. And I think I maybe can speak for my fellow candidates here. It's very challenging to be able to run a statewide race and have sufficient funds to do that, and to make sure that each of our messages are able to get out with the money that our campaign committees are able to raise for us. Given that, I am willing to accept PAC money. And with respect to the question of political parties becoming involved in these races, I think I cannot control people who are willing to provide support or assistance to me or to either of the other candidates in this race. And I'm certainly grateful for those who go out and do things to support my campaign. That's not solicited help. It's support that is provided and offered by people who want to support a candidate. And so, as I have said from the outset, I am happy to accept help and support from anyone who wishes to help and support my campaign. I'm also willing to speak to any group that invites me to speak to them and to share my message about my campaign.
Thank you. The next question deals with recusals. Judge Donald, you'll be answering first, please. Chapter 757.19, parent 5, requires a judge to file in writing the reason for recusal. Circuit court judges do it all the time. Why doesn't a Supreme Court judge? Would you state publicly your reason for withdrawing from a specific pending case? Judge Donald.
Well, Chapter 757 also outlines something that is very important. And I take this, actually 757.02. I will support the Constitution of the United States and the Constitution of the State of Wisconsin. I will administer justice without respect to persons and will faithfully and impartially discharge the duties of said office to the best of my ability. So help me God. That is an oath that every judge takes. And then to ensure that that oath is maintained and there is connection between the citizens of this state, it is vitally important that if there is an appearance of a conflict of interest, that a judge should recuse themselves and should state so publicly, whether there is an actual conflict or an appearance of a conflict. It is my belief that if we want to restore integrity and faith in our Supreme Court, that it must start with each justice individually. And that's the only way that the bar and the citizens will believe that things are changing for the better. So yes.
Thank you. Justice Bradley, please.
With respect to stating reasons for recusal, that can present some issues for newer judges coming from private practice, for example, because if the reason that judge or justice is unable to sit on a case relates to a prior private representation of a client, that judge or justice would not necessarily be in a position to disclose the reasons for recusing in that particular case because they might be then disclosing a client confidence. So to have a blanket rule that requires a justice to disclose the reasons can be problematic. I'm giving you just one example. Sometimes the reasons are quite apparent. As I came from the Court of Appeals, I am of course statutorily unable to sit on any case as a Supreme Court justice that I previously handled on the Court of Appeals, so that's something that could be readily apparent to the public. But with respect to recusal as a general issue, each judge and justice is required to examine the case and the parties and the facts before that judge or justice and make a determination in accordance with the ethics code and with the statutes with regard to whether recusal is appropriate. That is an individual determination that each justice needs to make. And when I am making those determinations, I always follow the Judicial Code of Conduct as well as the statutes.
Thank you. Judge Kloppenberg, please.
There are cases in which it's appropriate to identify the reasons for recusal, and there are cases in which it would be inappropriate because of the risk of breaching confidences or impeding the fair resolution of the case before the court. So that decision has to be made on a case-by-case basis. The problem with our recusal rules more generally is that we have a subjective standard. It's up to each judge or justice to decide for themselves whether they can be impartial in a case. I believe that we should revise our recusal rules and impose an objective standard where if the question would be whether a reasonable person would believe that there is the appearance of partiality or a conflict of interest, and that test can then be reviewed by the other justices or on the Supreme Court or judges on a panel on the Court of Appeals. We also have a rule that was adopted verbatim from Wisconsin Manufacturers and Commerce that says that no matter how much money a party is given to a candidate, that's not a reason by itself for recusal. I think our entire set of recusal rules bears review so that we can instill confidence in the public that judges and justices are deciding cases without conflicts of interest and without partiality.
Thank you. The next question deals with expungement, referring to statute 973.015. Justice Bradley, it's your turn to go first. How do you feel about extending discretion to the circuit court to review expunction eligibility upon completion of sentence? Justice Bradley.
With respect to the issue of expungement, I defer to the legislature and the choices that the legislature makes in setting policy for the state of Wisconsin with respect to that issue, as with any other issue. And therefore, I restrict my comments somewhat because if there are statutory changes that are made, that is an issue that could come before the court. But having sat as a circuit court judge for several years, I will also express that I have great confidence in the circuit court judges to exercise discretion well in instances where expungement may be appropriate because the circuit court judges certainly sit in the best position to make those determinations.
Judge Kloppenberg.
The problem with our current expungement rules is that the judge has to exercise that discretion at the time of sentencing. And I believe that there's merit worth to the proposal that the judge retain that discretion at the conclusion of the service of probation. In general, I think that the circuit court judges, the more discretion they have at the sentencing stage, the more likely we are to have people being directed to the services they need and to the kind of programs that will ensure that they are penalized for their conduct and held accountable, but that they can return to be productive members of our society.
Judge O'Donnell. Excuse me, sir.
I think
Go
it's
ahead,
extremely important to ensure that we have a strong and independent judiciary. I think the judges can make those determinations. We have a community where we, in this state, incarcerate more African American males than any other state in the country. And the fact that we have labeled them as felons and have not given them an opportunity to get back into society, we put, in essence, a group of individuals who will then be forever outside the normal opportunities, outside the chance to participate in the fruits of liberty because of their transgressions. Now, if they do everything they can and they meet all of the conditions that are established, I think that that is something that can be determined by the circuit court either at the time of sentencing or at the completion of their sentence. I think it is only right and it is only fair.
Thank you. Next question comes from the audience. It deals with experience. Given the high volume of criminal cases reviewed by the Wisconsin Supreme Court, how many criminal jury trials and how many civil lawsuit trials have you either conducted as lead counsel or presided over as judge? And Judge Kloppenberg, it's your turn to go first, ma'am.
I was an Assistant Attorney General at the Department of Justice for 23 years, and I litigated cases in all circuit courts around the state and argued many times in the Court of Appeals and many times in the Supreme Court. I supervised both civil and criminal attorneys during my time at the Department of Justice. I had what was apparently the longest civil jury trial in the history of the department that went all the way up to the Supreme Court and was affirmed. Since I have been on the Court of Appeals in the 3.5 years, I have issued hundreds of opinions in all areas of law, and the expertise that I bring to the bench is unmatched. The Supreme Court itself actually, in the past, as an average over the years, handles about 25 to 30% of its cases have been criminal over the years, so it's really important to have a justice who has been exposed to all the different areas of law that affect the lives and communities of the parties that come before us.
Judge Donald, please, excuse me.
I have handled, and the only reason this figure comes to mind is because as a candidate in this race, it's my understanding that there are people out there who do what's called opposition research or something like that. Well, I've handled over 10,000 cases. Over 10,000 cases. I've had over 300 to 400 jury trials in our criminal courts. The one thing I know is that when you are doing a trial, it involves real people. There are real decisions that have to be made. And I've spent the last 20 years of my life making those decisions. Now, there are some people who may criticize me publicly because I've been a proponent of what I call therapeutic jurisprudence as it relates to the treatment court. Because I don't think everyone needs to be sort of locked in to a conviction. And so I believe that given my experience as a trial court judge, that is vitally necessary and important to have that experience on our state Supreme Court. And I would love to be able to be in a situation to actually talk about what goes on at the trial level. In fact, Justice Crooks, who had 20 years as a trial court judge before he was elevated to our state Supreme Court, I am in that similar spot. So I would understand how those cases are handled and how those matters are addressed.
Justice Bradley, please.
Thank you. The job of a Supreme Court justice is to be able to review and analyze complex issues across all areas of the law. I have spent 20 years in the legal and judicial professions. I started out my career with 16 years of private legal practice, where I handled all manner of complex civil litigation cases and also served as an arbitrator in a quasi-judicial role. I then moved to the judiciary and handled hundreds of cases on the juvenile court bench in areas involving termination of parental rights, children in need of protection or services, and juvenile delinquency. I then moved to the Court of Appeals, where I handled cases in all areas of the law, appealed from the trial courts of Milwaukee County. I now serve on the state Supreme Court, where I'm handling complex issues, again, in all areas of the law. And what I think is the most critical experience for a Supreme Court judicial candidate to have is to have a demonstrated record of having a judicial philosophy of applying the law as it's written. And that is the judicial philosophy that I bring to the state Supreme Court, in addition to having served at each level of our judicial system on top of 16-plus years of complex private legal practice.
Thank you. Perhaps a final question to allow for closing remarks. This is another question from the audience. Thank you. How does the statement apply the law as written square with the Supreme Court's obligation to consider petitions for review on the statutory requirement that, among others, quote, a decision by the Supreme Court will help develop, clarify, or harmonize the law? The reference here is to 809.62, parent 1R, parent C, and it's Judge Donald's turn to go first. Sir?
Well, whenever I hear the phrase apply the law as written, sometimes it just makes me think that maybe there's been a predetermination. And that concerns me. I think what is necessary is that you have a judge who will understand the facts, will understand the case. First, you start with a case. You look at the facts, you look at the law, and then you square that with our Constitution. Because there are times, and not to say that the legislature doesn't get it wrong every time, but there are times when there is a law that when it is applied unfairly. And it weighs heavily on a particular group of individuals. So I think it's extremely important to ensure that you look at the facts as well as the law whenever assessing a case.
Justice Bradley, please.
There is certainly a law development function of the state Supreme Court where there isn't a constitutional provision or a statutory provision, and we are dealing with the common law. Absolutely, the state Supreme Court has a role to play in developing the law. My approach in developing the law under those circumstances is to look at the body of case law precedent that has developed that surrounds the issue, and I take a restrained approach because the people of Wisconsin have the right to rely on the law that has developed in the state of Wisconsin and not to have sharp diversions and changes just because membership on the court has changed. And so when I'm looking at the law development function that I hold as a state Supreme Court justice, I always carefully study the body of common law that has developed, and that informs the decisions that I make and the opinions that I write, and I take a restrained approach to that.
Thank you. Judge Kloppenberg, please.
There are holes in the law, and that's why there are so many of us lawyers and judges around the state. And we rely on the Supreme Court as the final arbiter of what the law is. And when the law is to be developed, then it should be done so in a principled fashion that is clear and understandable to the lawyers and the parties and the judges and the public at large. The key, and what I have shown myself to do in my 3.5 years issuing hundreds of appellate decisions on the Court of Appeals, is to be focused and disciplined in my analysis, to listen to the parties and their arguments, to consult with my colleagues, to do independent research, to go where the facts and the law take me rather than deciding ahead of time who I want to win and trying to pigeonhole the law to get to that result. It's to answer the question that is asked by the parties in a focused and disciplined way, not a question I might choose to answer, and to write an opinion that is clear and understandable.
Thank you. Thank you, candidates, for your answers to questions. We've now come to the closing remarks. This has also been determined by a drawing we had earlier. Justice Bradley, would you go first, please?
Thank you. When I was a circuit court judge in Milwaukee County, as I mentioned, I served in children's court, and I was called upon to make decisions that affected people's lives very intimately and directly. I was handling cases involving, for example, termination of parental rights. And I got to know the parties who would appear before me, the parents whose liberty interests in being able to raise or even see or speak to their children were before me. I got to know some of the children whose cases were in front of me. And as a human being and as a woman, I would develop my personal feelings about where I would like to see the case go or what I would like to see happen in the case. But in order to ensure that I did not let my personal feelings interfere with my judicial decision making, I would look at the law that I was called upon to apply in the case of a termination of parental rights case, statutory factors to guide me in my decision. I would apply the law as written by the legislature to the facts presented before me, and I found my decisions writing themselves. This allowed me to ensure that the judicial decisions that I was making were always in accordance with the law and to make sure that my personal feelings would not affect that judicial decision making. I bring this example to you by way of example because that's really how I approach each and every decision that I have made as a circuit court judge, as a court of appeals judge, and as a Supreme Court justice. I am always guided by the text of the law that I am called upon to apply, whether that is statutory, constitutional, or common law. That is the judicial philosophy that I am bringing to the court on top of my 20 years in the legal and judicial professions. Thank you to all of you who have joined us for this forum. I really appreciate your attendance. And again, it is my honor and privilege to serve the people of Wisconsin as a member of the state's highest court.
Thank you. Judge Kloppenburg?
As I said at the start, the stakes are high and the choice is clear. The people of Wisconsin have an opportunity in this election to choose a new justice for our Supreme Court, a justice who they know will deliver on their promise to be independent, a justice who they can count on to stand up to the partisan politics and special interests that threaten to undermine the respect for and authority of our court. I am that candidate, and I'm the only candidate who can do that because I'm the only candidate who consistently has done that throughout my entire career and in this campaign. I'm the only candidate who has people publicly endorsing me from every county in the state, from Congressman Obie up north to civil rights pioneer Vel Phillips here in Milwaukee. It would be an honor to have your support and your vote on February 16th. Thank you so much.
Thank you. And Judge Donald, please.
There's a phrase that I've used in this campaign. That's from Martin Luther King. And he talks about the arc, the moral arc of the universe. And that he says that it bends towards justice. It is long and it bends towards justice. Well, I'm here to tell you that that arc does not bend towards justice by itself. It requires people. People who believe in fairness, who believe in impartiality, who believe that we need a strong and independent court to stand up to the abuses of an executive or legislative branch. That's what keeps our democracy in balance. And I am running to ensure that we have a balanced and fair, impartial court. I'm using my experience as a trial court judge of 20 years, the thousands of cases in which I've handled, my life experience of growing up in a predominantly white neighborhood and being treated differently. I know what it's like to struggle. I know what it's like to be treated unfairly. Our citizens deserve a court that is not beholden to ideology or politics or special interests. We deserve a court that is there for the people. It is vitally important that we ensure that we maintain that independence. And I'm that candidate that can make sure that that happens.
Thank you. Two reminders before I turn it over to Judge D'Amato to close. First of all, the primary is February 16th. The general election is April 5th. If you want to see a video of this, Wisconsin I will be making it available on its website, wisi.org. Your Honor?
I have a few thank yous and a few reminders as well. But first of all, I'd like to apologize to Gwen Connolly. Gwen is running unopposed for the Circuit Court. She has been here. I neglected to introduce you at start, and I apologize. In terms of thank yous, first of all, I want to thank Steve Walters for being the moderator of today's forum. I want to thank our three candidates for being here today, giving of their time. They are very busy. They have schedules that I wouldn't want to have to deal with, but they put aside the time to be here today to answer your questions, and because you are the people who will be making your votes and who will be deciding the election. So thank the candidates for being here.